Furlough and parole, the differences and reforms. The objective of both furlough and parole is to create a balance between an inmate's rights and those of the society to avoid further harm from the inmate. Both are a form of conditional release, which means the inmate must follow the conditions set out in the order allowing furlough or parole. For instance, marking their presence at a nearby police station at regular intervals. There is no uniform legislation to deal with furlough or parole. Different states have their own acts governing the two forms of release. Furlough is granted as a matter of right to prisoners. Its main objective is to break the monotony of imprisonment and allow the inmate to maintain contact with the outside world. Hence, it is not necessary for the granting authority, the Deputy Inspector General of Prisons, to study or note reasons for granting furlough. It is granted to convicts serving long imprisonment. Parole, by contrast, is not seen as a matter of right. It is given to a prisoner for a specific reason, like the death of a relative or to attend the marriage of a family member, and is subject to the prisoner's behavior. Parole is usually, but not necessarily, granted when the conviction has been for minor offences and the term of imprisonment is short, as defined by the state's prison manual. The granting authority for parole is the Deputy Home Secretary of the state government. In some states, the application for parole along with a police report on the applicant is forwarded to the district magistrate, who, in consultation with the state government, either rejects or accepts the request. Both parole and furlough can be denied if the competent authority is of the opinion that releasing the inmate would not be in the interest of society. Also, as laid down by the Supreme Court in the state of Haryana versus Mohinder Singh, 2000, when a prisoner is on parole, his period of release does not count towards the total period of the sentence, while when he is on furlough, he is eligible to have the period of release counted towards the total period of his sentence undergone by him. How remission is different from furlough and parole. Remission is distinct from both furlough and parole in that it is a reduction in sentence as opposed to a break from prison life. Section 432 of the Code of Criminal Procedure allows state governments to grant remission to convicts. The provision states that when any person has been sentenced to punishment for an offense, the appropriate government may, at any time, without conditions or upon any conditions which the person sentenced accepts, suspend the execution of his sentence or remit the whole or any part of the punishment to which he has been sentenced. In essence, a prisoner can be released prematurely if the state government so desires. But the exercise of this power is in itself subject to judicial review. Prisons is a state subject under the state list of the 7th schedule of the Constitution. The management and administration of prisons fall exclusively in the domain of state governments and are governed by the Prisons Act, 1894, and the prison manuals of the respective state governments. The Prisons Act further says that only states can make rules regarding the release of prisoners on furlough, parole and remission, as part of the correctional process in jail reforms. Criminal justice administration in this era is different from the past. With changing times, the focus on correction, reformation and rehabilitation has increased and harsh, retributive forms of punishments are now losing value. Time and again, multiple reports across the world have focused on this aspect. My suggestions in reforming Indian jails or prisons. The Prisons Act, 1894 was introduced by the Imperial Government of India, the British Government of India, which was designed to imprison Indians in a very non-humanized manner. But nothing has been done to reform the state of prisons in the Indian government after that, including the present Modi government. Imprisonment should be for reforming convicts and correcting them. So the prisons actually should be renamed as correctional facilities. By such a change in name, the attitude of government and jail authorities will change too. Towards reforming convicts, the jail for criminal imprisonment and civil imprisonment should be located in different facilities. Include representatives of various verticals of society in reforming jails and facilities at jails. The democracy is by the people, of the people, and to the people. It's not for the people in power to become autocrats. Finally, a quote: imprisonment is as irrevocable as death. Imprisonment, as it exists today, is a worse crime than any of those committed by its victims. The veriest and most loathed worldly life that age, ache, penury, and imprisonment can lay on nature is a paradise to what we fear of death. Thank you.